Good afternoon. Thank you for joining us today. I'm Alicia Kepke from Trenum Law. I am your CLE director for the Florida Bar Labor and Employment Law section this year. You are joining us today for course number 9577. Again, that's 9577. Before we get started, I want to remind you that our next upcoming CLE is January 15th through 16th. That's the annual update and certification review that will be held in Tampa at Le Meridian Hotel downtown. There's also an opportunity to do the craft boat cruise, which is by Sparkman Wharf in Tampa on the evening of the 15th. So you separately sign up for that, and we hope that you'll join us for that 2-day seminar and the craft cruise, which will operate as our reception that evening. That's January 15, 16. Today we have the topic, of course, is FLSA collective actions. Before we get started, I want to thank Jason Pill, Chuck Ice, in addition to our fabulous speakers who decided to come in and pinch hit for you today, which we very much appreciate. So let me tell you who your speakers are. First, we have Linda Bond Edwards. She is a Florida Supreme Court qualified arbitrator. She's also a Florida Supreme Court certified circuit and county mediator. In addition, she's a AAA employment, consumer, and commercial arbitrator. She has roughly 30 years of employment litigation experience in both the public and private sector, along with over a decade in corporate human resources. She serves on the executive council for the labor and employment law section of the Florida Bar, and she has received numerous accolades through her career, including the 850 Magazine Pinnacle Award and Florida Trend Legal Elite. Our second presenter today is Wesley Thorp. He's with Phelps Dunbar. He is a 2022 graduate of the University of Florida, where he served as editor-in-chief of the Florida Law Review and was inducted into Florida Blue Key, which is a university honor society. He also, prior to joining Phelps, served as a judicial law clerk for the Honorable Marcia Morales Howard in the Middle District of Florida. Now, during the presentation today, if you look at the bottom of your screen, you'll see a little tab for Q&A, and you can put your questions in there, which I will then share with the speakers. So make sure you type your questions in. We'll share those with the speakers. And with that, I will turn things over to our speakers. Thank you both.
All right. Let me go ahead and share the presentation here. Is that coming through?
Yes.
All right. Well, good afternoon, everybody. My name is Wesley Thorp, and for my part of the presentation, I'm going to be giving sort of a high-level overview of FLSA collective actions and a little bit of the structure of how they're different from Rule 23 class actions, and why it's such an unusual and interesting mechanism. And then I'm going to turn it over to Linda, who's going to talk about a lot more of the sort of ethical and strategic implications of the collective action mechanism. So, as mentioned, we're looking at the FLSA Section 216B collective actions, talking a little bit how they compare to Rule 23 class actions that are a little bit more familiar. Also talking about some of the sort of unique ethical challenges that come along with collective actions and practical risk management, so issues that can arise and how to prevent some of these communication challenges that can be raised. So Section 216B of the Fair Labor Standards Act is kind of unique because it's an opt-in process rather than an opt-out process. When you think about a class action, typically it's a situation where you have one or maybe a group of named plaintiffs that are the actual parties to the case, and then you have other individuals that are members of the class and that they're bound by the result of the case, but they're not actually parties to the case. One of the unique things about collective actions is that the parties and the members of the collective will actually affirmatively opt in and will join the case as full parties. So they're, subject to the rules. They're considered parties for, all sorts of procedural purposes. They, by default subject to standard discovery rules, things like that. I say by default because in practice it won't always be proportional or probative to actually conduct discovery on every single opt-in, especially if you have a very large class. But it's not because they're not parties. It's the court's inherent authority to conduct that. One of the other unique things about the collective action process is you have this two-step certification that we're going to talk about, where the court will conditionally certify the collective to, give notice to the class, essentially. So that's kind of where a lot of these unique elements come in, is you're conducting discovery and litigating about whether employees are similarly situated, while these employees may be considering whether or not to actually join this case as litigants. So you can see how that would kind of create some tension and would require some care in communication, things like that. So the goal of Section 216B is to balance employee rights and judicial efficiency in these cases. A lot of times you may have, hundreds, possibly even thousands of employees that are all subject to the same policy. And so the legislative intent was to create a vehicle where you could have, lots of people opting into a case if they want to pursue those claims and have those all adjudicated at the same time. But like I said, it's also a little bit different from a class action because you're not actually deciding the rights of parties that are not members of the case. So under the FLSA, it says that employees can bring collective actions for and on behalf of themselves and other employees similarly situated. This has been extended to the ADEA and the Equal Pay Act. One difference you may notice here, especially if you're more familiar with traditional Rule 23 class action, we're kind of building a lot of these procedures off of the similarly situated language. There's not sort of a clear rule that breaks it out the same way as you have, with a Rule 23 class action where you have a list of criteria that the court's actually going to go through. So a lot of this is going to be jurisdiction specific and looking at specific case law, interpreting it and building out these procedures. There's a lot less structure in the actual text compared to a Rule 23 class action. So over the last 75 years, this has created a lot of need for courts to develop how they're going to administer these cases, how they're going to define what makes an employee similarly situated to another employee. And the really big question is, when is the court going to authorize notice? Because the big deal with this is that there's actually going to be a court-approved notice that goes out to all of the employees, many of whom might still be employed by the defendant, that's going to let them know that there's a lawsuit going on. They have a right to join it. It's going to give them some info about the case. And again, you can see how that would create issues where people would need to be mindful of communication and ethical issues. There are 4 different frameworks that courts have developed. If you haven't, litigated a collective action case in the last 4 or 5 years, that may come as news to you because 3 of these are actually a lot more recent. So we're gonna talk about the main one that applies, and then I'm gonna share some of the more recent developments that other circuits have started to adopt in analyzing this. So this case, Lusardi v. Xerox Corp., is really the first case to address how these collective actions should be structured and administered. This is the case that most courts cite to and look to see how to approach that. And this creates a 2-step process of quote unquote conditional certification. So the plaintiff will, put forward an argument that there is a class out there of similarly situated individuals, and they get very broad deference to issue notice, based on the court's review of the evidence. Spoiler alert, this is the approach that's followed in the 11th Circuit. So, probably the one that's most relevant to most people here. So while we are going to talk about the other cases that have developed recently, this is the one that is kind of the main one for most of our purposes. So this is a fairly plaintiff-friendly standard. It's often described as a lenient standard. You'll see that word come up a lot in the case law. There's not a very strong showing that's required to issue notice under Lusardi. Most of the effort at this point is going to go into the defendant, building the case that they're going to present at what's called the decertification stage. So at the end of the opt-in period, you have a group of plaintiffs that have opted in, and then the defendant will get to present evidence that, these individuals are not similarly situated. So that might be that, some of them might have an arbitration agreement, others don't. Maybe they worked under different managers or were subject to different policies. Things like that might mean that the case isn't really appropriate to resolve in a collective action. So that's sort of the baseline framework that, as we'll see, other courts have modified. But like I said, this is what's followed in the 11th Circuit, so probably most relevant to people here. So recently, this is 2021, Swales v. KLLM Transport Services, and this is a break from this Lusardi approach. So under Swales, the Fifth Circuit essentially said it's not a very deferential standard. The court should really look at the full body of evidence before issuing notice. So this is a lot more rigorous. You'll recall under Lusardi, it's usually called a lenient standard. Swales is a lot more rigorous. This places a lot more of the burden on both parties. You can also see how this would, also impact some of the litigation strategy and the ethical issues, because now you have both parties that are trying to build their cases of evidence often before notice has even gone out. It may not even be settled what employees are actually going to get the notice as the parties are conducting this discovery on these same individuals. And then, a few months later, those individuals may end up being parties to the case. So this was a development that sort of broke with the traditional approach that's followed in the 11th Circuit. There's also this case, Clark v. A&L Home Care and Training Centers. And this actually went even further than Swales, because it really rejected the idea of this term conditional certification to begin with. So you might have noticed that wasn't quoted, anywhere from the FLSA as a term that shows up in the statute or anything like that. It's really just a term that courts have adopted by analogy to a class action. So the Clark court said that there's no real basis for that in the statute. This is different from a class action. We don't need to call it that. And so the Sixth Circuit approach for issuing notice is essentially the preliminary injunction standard. So they, like it says here, they look at whether there's a strong likelihood of success on the merits. To be clear, that's the merits of showing similarly situated, not necessarily the merits of the overall claim. But again, this is requiring a lot more evidence up front than you might have, for example, in the 11th Circuit. So that's another difference that, again, you can see how that would have a lot of impact on, discovery strategy, and also raise those ethical implications of, communicating with potential class members, things like that, from early on in the case. Again, the people that are sort of speculative members of this collective, early on in the case might be joining later as full party plaintiffs. And these are people that are often going to be employed by the defendant, throughout this whole process. They may have questions about the litigation that they're, talking about with each other and with, their bosses, things like that. So there's lots of, potential issues that can arise there. The most recent approach to this structure is this case, Richards v. Eli Lilly and Company. And this is a sort of, well, it's a very flexible standard for district courts. The Seventh Circuit didn't reject the two-step process. They kind of gave courts discretion to use it if they think it's necessary or ignore it if it's not. And a lot of that depends on whether the court thinks that, discovery is needed from some of the opt-ins, that we need a better sense of, which individuals are opting in and what their actual position was before the court can decide whether they're similarly situated or not, or whether, based on the way the class is presented, that the court can just look at the evidence before it and make a determination. And that's left sort of within the district court's discretion under the Richards approach. So this is, again, a departure from the traditional rule that puts the burden on both parties. And again, those same concerns of, both parties are conducting discovery and, on people that may still be employed by the defendant and may become parties to the case later on, even though they're not currently. Most recently, the Ninth Circuit, they reaffirmed that they follow the Lusardi two-step approach. So they did not take one of these modified approaches that we just talked about. And it, in fact, specifically disapproved of some of them. But I bring this up because there is a petition for cert pending for the U.S. Supreme Court. So there may be an opportunity for the court to resolve this. So that's something to keep an eye on, especially if you follow a lot of these FLSA cases. I believe there also may be a petition for cert pending for the Seventh Circuit case, but I haven't looked into that one as much, so I don't know if that's the exact same posture. But who knows whether that will be accepted? But that's something I wanted to put on the radar. So again, assuming the two-step certification process applies, like I said, this is the one that applies in the 11th Circuit. It's a lenient standard to issue the notice. So once the court determines that there's a basis to issue notice, that will be a court-approved notice that will be mailed out, usually by physical mail, often by email as well, either instead of or in addition to the physical mail. And that will go out to all of the prospective class members, and they'll get an opportunity to join the case if they choose to. And then at the end of the notice period, there's the decertification phase where the defendant can try and decertify the class and argue that the class members and the opt-ins are not similarly situated. The plaintiff, of course, will usually argue that they are, and the parties will litigate about that. This is a much stricter standard of review because, of course, we now know who the opt-in plaintiffs are, and there's been an opportunity for more discovery on that issue. I mentioned it's a lenient standard for issuing notice, but it's not just a rubber stamp process. So it does still require plaintiffs to go through and build their case and their arguments. It's not just an automatic given. And at the same time, defendants have to be mindful of whether it's worth fighting on that issue. A lot of times they'll negotiate some kind of conditional certification that's strategic and focus on trying to prove decertification later on rather than trying to oppose whether notice should issue in the first place. So just to kind of recap how this is so different from a traditional Rule 23 class action, most Rule 23 class actions are going to be opt-out cases where you have, the non-parties that are members of the class. They're allowed to opt out, in which case they're not going to be bound by the result. But if they do nothing, they're bound by the result. And also they're not party plaintiffs the same way. They're just non-parties who are bound by the result of the case. Whereas for the FLSA, there has to be an affirmative opt-in by the plaintiffs. And usually this will be a notice of consent to join that gets filed on the court's docket and notifies the court that that individual wants to join the case as a party plaintiff. For those of you, if there's anyone who, like me, is a massive nerd for civil procedure and jurisdiction, you may be wondering if that ever raises like personal jurisdiction issues and how that comes in with, Rule 4 and all that. That's a rabbit hole that gets very deep and very, very interesting, a little out of the scope of today's discussion, but a good one to look at if you're interested in that kind of thing. You can also see here the Rule 23, you have very specific criteria for this rigorous analysis of certifying a class under Rule 23, a little bit vaguer for the FLSA. And again, part of that is because there's this sort of conditional certification at the first step where the court is issuing notice, but it's reserving on the question of whether they are actually similarly situated. So this can have massive implications on litigation strategy, discovery strategy, the kinds of communications that are, appropriate or inappropriate for, having with these potential class members. And of course, as it notes here, it's possible to have a 216B opt-in class and a Rule 23 class action in the same case, especially if there's state law and federal claims in the same action. So that can add to the complexity of this procedure. So with all that being said, I'll turn it over to Linda to talk about some of the ethical issues and ways of navigating those.
Good afternoon, and thank you for joining us, and thank you, Wesley, for providing the overview for our session for today on collective actions and the wonderful world of class actions if there is a state law claim. And my task is to the extent that I can, share some ethical dilemmas that might arise if someone chooses to file both a collective action and a rule and a 216B action in the same case. And as Wesley mentioned, that comes about when plaintiffs will choose to, a plaintiff's counsel will choose to bring a federal action for under the FLSA, and then a follow-along Rule 23 class action under state law. And so we're going to look at some of those dilemmas that may come up when there are both of those cases present. First of all, just looking at the ABA Model Rule 7.3, there is a limit on attorney solicitation to prevent improper persuasion of potential class members. Again, that arises more perhaps under Rule 23 than in collective actions under Rule 216B or under Section 216B. But I want to, a case that's not mentioned in your materials is a recent case, or maybe not so recent, but a pretty amazing case out of the 11th Circuit dealing with certification. And that case is is Roberts versus Public Supermarkets. And it was a case where the 11th Circuit rejected the certification application by the plaintiffs and allowed the cases to proceed as individual matters. And one of the things that kind of happened in that case is that there appeared to be some pretty aggressive solicitation for parties to enter and be a part of this case. And so when you look at, and Wesley certainly mentioned this during his portion of this presentation about the neutral communication requirement. And as it says here, the court has to approve the notices so that they remain neutral, so that the attorneys, and it's, you know, it helps the attorneys perhaps as much as the party involved, so that there is not undue influence on recipients, and to maintain fairness. And so attorneys have to be extremely careful in how opt-ins come into the case, and what information is presented to them should they decide to opt in a collective action. Then there must be clear disclosure of the material facts to avoid misleading statements about legal rights and obligations. And again, to some degree, in the Roberts versus Publix case, and that case is still going on, is still an active case in the Middle District of Florida. There has to, the attorneys have to be sure that they're not promising employees or potential plaintiffs that they are not being promised that, yes, you do have a case, and yes, you're going to receive some sort of damages, and you don't really have to do anything. So again, leaning more towards the court required notice to be sure that plaintiffs are not misled, to ensure that they have statements about what their legal rights are, and that, you know, if they're told you don't have to do anything, it reminds the plaintiffs that they may have to do something. You know, they may be asked for records or information regarding their claims, things like that. So the communication does present some challenges to attorneys to be sure that what they're telling potential plaintiffs is consistent. And, you know, for our purposes, we don't want to get into claims about false and misleading statements made to clients. So one of the things that does happen and can happen with non-compliance with the rules of professional conduct is that we fail to follow those rules. And I say collective we. If any lawyer fails to follow those rules, you certainly don't want to have to fight against reputational damage, and also undermine the collective action integrity, because there may be a putative class out there, but if your reputation has been that you don't treat those plaintiffs correctly, that also gets out in the atmosphere and may affect your business going forward. So it's extremely important to remember about those solicitation rules, review the rules if you are entering into a collective action or a class action lawsuit. It's extremely important to remember those rules. Next slide, please.
Linda, we have a request for the citation to the Roberts v. Publix.
Okay, I'll give you, here's the case number for that case. It is case number 823-CV 2447 WFJ CPT. And this is the site to the Middle District case. It's also 2024 WL 475-3703. And again, this is from the Middle District of Florida.
Thank you.
It is a case that is worth a good read, and it outlines, and that leads me into the next section. And if you'll just go to the next slide for me, Wesley, for risk mitigation and practical insights. Excuse me. It does, or this case does outline some of the strategies that the council in the public's case engaged in as they were trying to defeat the certification, the initial certification. One of the things, again, that this case talks about is the fact that sometimes when plaintiffs attack well policies, if that's a word, or employers that have pretty strong policies, that sometimes the attorneys will be fairly aggressive. The defense counsel will be fairly aggressive in defending against that initial certification that Wesley talked about. In this particular case, in the Roberts case, the public's attorneys requested, and the court granted their motion for some initial discovery and allowed them to conduct some depositions of some of the individuals prior to ruling on the certification. And as with any case, when certification comes up, it is based on pretty much the four corners of the complaint that as Wesley talked about, similarly situated, and usually that's it can be fairly bare boned or it can be pretty fleshed out depending on how the attorney chooses to plead it. But in those instances, or in the instance of Roberts, the public's attorneys really try to give the court more information about public's policies, more information about their practices, and more information about the fact that publics had a policy and a practice, if you will, of really paying people overtime. And to just a little bit of the specifics about the case, the allegations were that some of the assistant managers were required to work off the clock, and that publics knew that this was going on because of their policies, or their labor costing kind of policies. And what Publix was able to show, again, that they had a history of paying overtime to their non-exempt managers, and that they required approval, of course, but again, if something happened, they would still pay them. And so they were able to get all of this information into the record before the court ruled on that initial certification process. And so when you start to look at what some of the strategies can be, our attorneys can be pretty aggressive, if you will, in that initial certification process, to especially if you find that the employer, the defendant, has good records, strong policies, and strong practices, that it's not as difficult, if you will, to defeat that certification. But you have to be aggressive in trying to assert those things up front to avoid that certification process. And again, the district court judge did allow them to do that. So that's one of the strategies that you can use. And one of the things, some of the other risk mitigation strategies include training, standardized templates, and ethics counsel guidance to prevent legal pitfalls. As you know, in FLSA cases, they can take many forms, and the training part of it, to train employees, number one, on how to keep track of their time, to be sure that they are following the employer's practices. Extremely important as a risk mitigation strategy. Also, the standardized templates, some sort of way in the employers should have some way for employees to bring forward if they believe that they are not being paid properly, bring that information forward. And again, I suspect that many who are on this call who are defense counsel have done that. And if you're on the other side, if you're plaintiff's counsel, you love to hear when a potential client says, they told us don't write everything down. And so it again helps with the mitigation strategy if the employers have some sort of training going on, if they have templates for reporting time, and they are being sure that they're getting good counsel from both their ethics counsel and their substantive defense counsel. Some of the common ethical pitfalls, again, just being sure that you're not providing misleading information. One of the things that arose in the Roberts case, again, was the aggressive marketing or the aggressive kind of solicitation or alleged solicitation of clients, and leading to confusion from many potential class members who are saying, well, I kind of did receive overtime when I worked it. I kind of didn't do this. But if they're constantly being told that, and not that this happened in this particular Roberts case, but if those employees or those potential plaintiffs are constantly being told, well, yes, you do have a case, then again, it may present some ethical dilemmas for them. With regard to the practical compliance tips, this can get a little bit challenging because in those instances, it says if you're drafting the neutral notices, if you're making inquiries about handling, and sometimes these cases have a lot of parties. Or the classes or the potential class can be pretty large, and sometimes there are multiple staff members handling those claims. So it becomes extremely important to be sure that your co-counsel, all of your staff members, all of those folks understand the implications of getting notices from people, from potential plaintiffs, being sure that they are not being provided with information that is misleading, having them even engage in actions that having the potential plaintiffs engage in action that may not be as upfront as perhaps it should be. And so it requires much attention to these cases to be sure that the information being shared with potential plaintiffs is accurate, that it is not misleading, that even if the named plaintiffs, if you will, are saying to counsel, well, there are lots of us out there, to be sure that, again, that information, any information that is coming or appears to be coming from counsel, that information has to be neutral, it has to be truthful, it has to be consistent with the law to be sure that the attorney doesn't find themselves in a position where they are violating the rules of conduct and over-promising, if you will, that about the strength of the case, about where it's going to go, how long it's going to take. All of that information certainly does require the employee, the counsel, to be neutral in the conversations and provide the person with the named plaintiffs and potential plaintiffs with information that will help them move the case along. In most instances, or what I've seen, is that many of the cases will proceed through the collective action process, And the class action piece of it, the Rule 23 class action portions of the case, will generally kind of lag behind the collective action to ensure, and it probably makes, from a strategy standpoint, may make sense to do that because you're allowed to be sure that the people who want to be in the case are actually in the case, rather it's so that they are allowed to opt in into the case, rather than trying to have this broad sweeping class with people that may or may not be part of the analysis to determine whether or not the class action really is a class. So again, most attorneys will go through the 216B process, the collective action process, before they go through the Rule 23. So are there other questions that we may have, additional information that you would like to have us share? Alicia, any additional questions in the Q&A? We must have done a super fantastic job if there are no questions.
You sure did. We have one pending question. What advice would you give a lawyer that is not working in employment law, but would like to pivot into FLSA collective actions? Is there a practice area in law other than employment law that would make this transition easier?
Oh, wow. I will tell you, as Alicia said during the introduction, prior to going to law school, I worked for 10 years in human resources at a Fortune 100 company. And so that was my first introduction to the Fair Labor Standards Act, was from a practical standpoint in understanding a classification that my employer was using called hourly salary, which I'm like, it's almost like an oxymoron, can't have both. And so you can certainly read the case law. You may even join some kind of human resources organization, because that's usually those are usually the folks who, from a very practical standpoint, help you understand it. But it has a lot of, the Fair Labor Standards Act, I think, has more intricacies perhaps than other areas of labor law. It is the oldest employment law in the books. The Fair Labor Standards Act was passed in 1938. And as you heard Wesley talk about a case that is pending certification in the United States Supreme Court, it's still having some nuances that are challenging. So just learning or reading the cases is probably the best thing, and just understanding what the basic premises are. And as broad as it is, it really turns on two kind of simple things. One is that you are required, employers, if they are eligible, and it's usually those folk who have gross sales that exceed $500,000, and that number has not changed in a long time. And those employers are required to pay time and a half for all hours worked over 40 in a work week. And there are all kinds of little nuances about, well, what is work? All of that. So that's one of the things. And the other is that you have to pay minimum wage, the federal minimum wage for all hours worked. And again, as simple as that sounds, what happens if there are deductions that cause an hourly rate to fall below minimum wage? All kinds of little nuances here and there. So a lot of reading is what it kind of comes down to.
All right, we have two more questions. Do you have any tips on managing a case involving both types of collective actions?
If you are in Florida, the Middle District and the Southern District of Florida have alternative case management procedures for FLSA claims. And I think this came about back in 2004 when the Middle and the Southern District were either number 1 and 2 or number 2 and 3 of the number of FLSA claims that were filed, and that's in the nation. And so at that time, they created alternative case management procedures, which really requires the parties to engage in conversation, if you will, and some early discovery in getting those cases to managing that docket. And so what you can do, whatever side you're on, is really to examine paychecks of the parties. If you are on the plaintiff side, looking at the pay stubs, whatever kind of pay records your potential client may have. If you're on the defense side, auditing your pay records, your employment records to see, just by way of example, one of the places where those kind of slippery kind of violations come in is on deductions from pay. Meaning, some employers, if you leave, or if you're about to leave and you still owe the money, they'll just take the money away from you. Well, I can't really do that. First of all, you have to have authorizations to make deductions from pay. And even with those deductions, you can't make a deduction from someone's pay that causes, again, their hourly wage to fall below minimum wage. And so if you are an employer auditing or you represent employers, auditing your pay records and your pay practices is one of the ways that you can mitigate potential claims.
All right, 2 more questions. Will raising a Florida minimum wage claim affect the ability to get class certification under the FLSA?
Again, you kind of conflated 2 things because if you're going to bring an FLSA claim, it has to come under Section 216B. And Wesley, please jump in whenever. Feel free to. But if you're going to bring an FLSA claim, it has to come under 216B. If you have a Florida minimum wage claim, you can bring that under Rule 23 without bringing a Rule 216B claim. But you'll still have to go through the Rule 23 class action, numerosity, fairness. You'll have to still go through all of that analysis if you're only bringing a Rule 23 class action lawsuit only based on Florida violation of the Florida minimum wage law. And you may have something to add on that, Wesley, but I think that's the way that it goes. If you're only bringing a state law claim, then you can just bring Rule 23. But as soon as you say the word Fair Labor Standards Act, it implicates Section 216B.
Yeah, that's my understanding, is that the 216B would just be for the federal claim. I don't know how it works in practice of whether you can have opt-ins assert those additional claims separately, or what the procedure would look like to do that. But those are the mechanism itself for the opt-in process is the federal one. And like I mentioned before, that can be brought in addition to state law claims. So that's possible, but they're sort of separate tracks for the federal versus state.
Now, I will tell you kind of an interesting twist with that. If you're going to bring just a federal 216B claim only based on federal law, when you calculate the back wages, you can only calculate back wages based on the failure to pay minimum wage based on the federal minimum wage law. For example, I believe the federal minimum wage is still $7.25 per hour. So even though your plaintiff may be earning a wage higher than that, if your violation is, or if your alleged violation is that they failed to pay minimum wage under the federal law, the back pay is calculated based on the federal minimum wage, not what your client is being paid. It's an interesting little nuance, and I don't have the case law right in front of me, but it's fairly easy to find. But it can substantially limit the amount of back pay that's owed, because again, if you fail to pay minimum wage, that's what the law is. You fail to pay minimum wage, not you fail to pay them their hourly wage. If you don't have a wage loss claim in addition to that, all you get is $7.25 per hour and whatever the back pay calculation is based on that.
Thank you. All right, next question. Can a union's collective bargaining agreement exclude benefits/incentives from bargaining unit members' regular rate of pay, part and parcel with other non-FLSA benefits?
I think I understood that question. And if I'm going to answer it by way of an example, and if it's not, let me know. And this is from practical experience. I had a case involving salary incentives for law enforcement officers who achieve certain educational levels. The employer was not adding that supplemental pay into the regular wage, and the Department of Labor found that that was a violation. And so they had to go back, add in that supplement pay, and then recalculate the overtime payment. And so I say that to say that it doesn't matter where the compensation comes from, whether it's a union provided benefit or not. If it is part of the regular rate, it has to be overtime has to be calculated based on the total compensation, rather than picking and choosing what's included and what's not. And the collective bargaining agreement can't contract away a right that is provided under the Fair Labor Standards Act.
All right. Well, those are all of our pending questions. So thank you both very much. We really appreciate you jumping in last minute. And thanks again to Amy Walker, as always, from the Florida Bar, and to Jason Pill and Chuck Ice. As a reminder, the course number is 9577. Again, that's 9577. And we anticipate sending the PowerPoint within a week. So look for that in your inbox. And as a reminder, we hope to see you in Tampa January 15th and 16th for the annual certification and update review. Thank you all very much and happy holidays.
Thank you all.